Well, Keith, welcome to the Center for Constitutional Studies.
Thank you.
We've had you here on campus talking with Jennifer Ruth in our conversation series about free speech on campus,
Mhm.
and that was an excellent experience.
Yeah, it was fun.
Keith, you are currently serving as the William Nelson Cromwell Professor of Politics at Princeton. You've been there for quite some time.
Quite some time, yeah.
I know that I, as a political scientist in the field of constitutional law, as well as constitutional development, constitutional politics, has benefited from your work and the work that a lot of your students have done as they've come out of Princeton over the years. Now, you're making a move soon.
I am.
Right? So
Yeah.
what's the new gig going to
So
be?
I will be moving to Yale Law School. I'll be the David Boyce Professor of Law at Yale Law School. And I'll have a secondary appointment in the political science department there. And so hopefully I'll have some opportunities to interact with students and faculty over in the political science department as well. But I'll primarily be doing law school, and that's where most of my teaching will be. And hoping to launch a center focused on academic freedom issues while I'm there as well. Try to do some research and hopefully some productive practical activities to help explain what academic freedom is, to develop best practices surrounding academic freedom, to think about what kinds of policies we ought to have around questions of intellectual freedom and free inquiry on university campuses and the like.
Well, that's great. I know you're not the only person we've had from Princeton here in recent memory, and I can say from direct experience that some of your colleagues can be very sorry to lose you, but Yale's getting a wonderful asset. I want to chat with you about your book, Repugnant Laws, which is subtitled Judicial Review of Acts of Congress from the Founding to the Present. I remember being very excited about this book when it came out. I was teaching constitutional law and sort of comparative courts and constitutionalism down at the University of Texas in San Antonio at the time. And I immediately sort of started using this book in some of my upper division seminars with students. And some of its findings are surprising. So I think to start with, I'd like to ask you about what's probably the most sort of world turned upside down finding in the book, which the standard account of American constitutional law and its early history is, and this still persists in an awful lot of textbooks and probably con law classes too, is that the Supreme Court established judicial review in Marbury versus Madison in 1803. At that point, we're 14 years into the experiment with the new federal government. So we get active judicial review of an act of Congress 14 years in, and then we don't get another one until Dred Scott versus Sanford in 1857. So we wait 14 years for the first one, another 54 years for the second one, and this was usually distinguished or contrasted with our experience in the 20th century, where we're accustomed to a Supreme Court that's very active. Now, you find that there are at least 2 instances of the Supreme Court invalidating a federal statute before Marbury, and 13 between Marbury and Dred Scott. So my first question is, how can the scholarship have misunderstood this narrative so deeply for so long?
Well, it's a bit of a good question, I think, as to why the scholarship is quite as off, and our historical sort of narrative about this is quite as off as it is. I think partially it is a question about judicial review is a more complicated practice than we tend to think. And so I think there's a lot more gray areas as to what counts as judicial review. And so once you start really trying to create an inventory of what are all the cases in which the court is evaluating the constitutionality of an act of Congress and then taking some kind of reaction to it, it turns out it's not entirely a straightforward project to figure out what that list looks like and which cases belong where. There's been some controversy over time. There were a lot of controversy about that in the early 20th century, which we sort of lost track of. But there was a time in which people really had arguments about, okay, what does that history actually look like? How many cases really? And then we sort of settled on a list and sort of left it alone, and it went away. Partially, I think the cases that sort of have fallen out of constitutional memory have fallen out in part because they are also, cases where the court was particularly unclear about what it was doing in many cases, right? They're complex cases, they're very fact-intensive cases, and so the language the court uses is much murkier, and so doesn't stand out nearly as much. But also partially they're just less politically salient cases. They don't matter very much in terms of the long-term rules they're establishing. They weren't in the middle of heated political controversy, so they don't look like Marbury. They don't look like Dred Scott, that in the sense of these cut against a lot of powerful political forces. They're matters of a lot of political controversy, and people remember the political contestation around them. And in some ways, that's not surprising. If we think about sort of later 19th or 20th century cases as well, the things we remember are the ones that are most politically controversial and most contested, and we sort of forget about all the ones that were run-of-the-mill, mundane cases that were not particularly controversial at all. We don't tell a story about those particularly, and so we don't tell a story that says, "Oh, none of those happened," because we just don't tell a story about it one way or another. But that's what a lot of those cases look like in the early part of the 19th century, and so I think they've also fallen out of memory just because they didn't have the same features to them that we were most concerned about when we talked about judicial review in general.
So political controversy is what
Yeah.
makes the Supreme Court's activity so noteworthy for the public, sort of puts it in the textbook, so to speak.
I think that's right. I mean, I think it puts it in the textbook, it puts it in the public consciousness. I mean, it is a sort of, one thing I did not appreciate until I started doing this project was just how uncertain, controversial even the history itself was at various stages, including that Congress had no mechanism for knowing if the court had struck down a law, right? So we know, so the Constitution is very clear about how the president vetoes legislation. There's a process, one, it authorizes him to do it. There's a process by which he does it. He informs Congress that he's done it. And so there's a whole clear record keeping process associated with that. There's nothing equivalent in the context of judicial review. And so the very first moments when the court is striking down statutes, there are those in Congress who are sort of worried about not only the fact that the court did it, but also why didn't anyone tell us the court was doing it, right? And why didn't we know about this? And so do we need some process by which the court should inform us of this going on? And then, as Congress usually does, it didn't do anything. And so it sort of passed by the wayside. Or in the early 20th century, it's much more politically salient about the court striking down acts of Congress and exercising judicial review more generally. Congress, in part, winds up asking one of my predecessors, Edward Corwin, who was a constitutional historian at Princeton, one of the great constitutional historians of the early part of the 20th century, to create a catalog of all instances in which the court had struck down laws of Congress, precisely because they thought they needed a record. They wanted to know what the constitutional law actually was, and there was nothing in Congress's possession in the early 20th century that even told them what laws have been struck down, what cases were striking down laws, what are the constitutional rules applying to us. And so what is now known as the Constitution Annotated that the Congressional Research Service maintains started from that effort in the early 20th century for Congress, just saying we need to get our hands around this practice that the court's engaged with. But it really highlights the extent to which all this was sort of happening in the background in lots of ways. And there's no sense of how do we routinize this and keep track of it. And so it's not terribly surprising then we'd wind up with different narratives about how often this happened. Those narratives were often politically motivated. So we had a bunch of radical Republicans during the Civil War Reconstruction process, for example, who would argue in Congress. Dred Scott sometimes they would argue Dred Scott was the only time the court had ever struck down a law as being unconstitutional. And so how outrageous it was that the court would do it and how they should never do it again. And others would say, well, I think they might have struck down some others and this kind of thing. And so often that narrative about how often is the court done has also been tied up with how legitimate is it for the court to do it. And so activists, whether it was the radical Republicans in the 1860s and 1870s, or whether it's populists and progressives in the late 19th and early 20th century, who were all very hostile to judicial review, also had an incentive then to downplay how often it occurred in order to make it seem like a very unusual practice, an extraordinary practice, one that would be relatively minor if we got rid of it, for example. And so it's both sort of a question about how controversial were the particular acts that make them stand out in our memory, but also what are we doing when we tell the story about how this practice is used and what the court does, and what are we trying to accomplish by telling the story? And that story often is a political story that serves political purpose to tell that story and tell it in a particular kind of way.
Well, and constitutional scholarship is a sort of
Yeah.
actor or variable in telling that story as well. In fact, you brought up, radical Republicans looking at judicial review during the Civil War, but even earlier, at the time of Marbury, you have Jeffersonian Republicans
Sure.
looking at exercise of judicial review, and then trying to situate that in the history of the founding,
Yeah.
and treating this as an innovation. Now, I've having taught and worked on the history of judicial review a good bit and the creation of our judiciary, I'd always in my courses worked through and in my scholarship worked through that history, and it looked like that at least at the time that the Judiciary Act 1789 is enacted, at the time that the Constitution is written, so whenever we're in that formative period of putting our institutions together and putting them into practice, judicial review comes up repeatedly, and it doesn't seem to be terribly controversial.
Right.
We actually
Right.
find there's famous Brutus essays and
Yeah.
the Anti-Federalists during the ratification debates. It's one of the few accounts, sort of
Yeah.
objections to judicial review you can find. There are a couple of people who raise objections in the Constitutional Convention. Overwhelmingly, when this idea comes up that courts are going to be involved in enforcing constitutions, it doesn't seem terribly remarkable. And then Marbury comes along and
Right.
Jeffersonians say, well, you Federalists are making
Right.
this stuff up.
Right. Right.
And of course, it was Jefferson himself who
Right.
said, maybe a Bill of Rights might be a good idea because, then courts will have something with which to limit Congress.
Right. Right.
And that turns out to be a bad prophecy.
It matters whose ox is getting gored.
That's right.
It's often true. It's and partially I think it's also true that during that early history, sort of the founding period, when state constitutions are getting written, when the federal constitution is getting written, there's a lot of people who anticipate something like judicial review, but not a lot of discussion about how it works, and so they have no real idea, I think, what the practice is actually going to look like in reality. And so it's one of those things that gets fleshed out in practice over time. And so, and it's one thing to sort of imagine something like that's going to occur, and it's another thing to actually see it playing out, and especially seeing it playing out in a way that hurts you politically.
Well, let's drill down on that,
Yeah.
how judicial review works and what we mean when we say judicial review. So maybe starting with the definition would be interesting.
Right.
In fact, the term itself,
Right.
You say in the book, and I thought when I read this book, I had been teaching comparative constitutions in courts. So I was accustomed to seeing things in other systems which judicial reviews become remarkably common in globally. But it's done much differently than it is in America. And one of the things I found interesting the first time I went through the book was you had this discussion of why the term judicial review. And there were other terms.
Yeah.
People have used judicial nullification, a judicial veto, even a term that's associated with you quite often, judicial supremacy, as opposed to a departmentalist understanding of constitutional enforcement and constitutional interpretation. So maybe you could help us understand why is judicial review the term we ought to use for this rather than some of those others?
Yeah, so I do think judicial review is a good term for it. It's but strangely, right, not one that emerges till very late in the day, relatively speaking. In part because the Constitution is not all clear about establishing the power. It doesn't say there's a power of the courts to overturn laws or refuse to enforce laws that are unconstitutional. So it doesn't lay it out like the presidential veto power. It doesn't name such a power as such. And so it's all being developed out of the implications of the system you're establishing, that there must be such an authority on the part of the courts to exercise. And for a long time, doesn't seem to be a lot of need to develop a specific language to talk about it, in part because it doesn't seem like it's that important of a feature of the system, and it doesn't occur that often. And so people don't need specific language. By the end of the 19th century, that no longer seems so true. And so it seems like it's become much more important. It becomes much more politically controversial. People want to be able to talk about what the court's doing. And if you're going to talk about it, you need a name for it. And so suddenly now there's a effort to figure out a name. And so Edward Corwin, the same person I mentioned a while ago, is also the scholar who comes up with the name Judicial Review in the first place. And so he's at the very beginning of his career is involved in these debates about how often was judicial review occurring and what's the justification, legitimation for it. And he uses judicial review as the phrasing to associate with this term unlike some other people who were involved in debates who were proposing all kinds of other terms. And his terminology caught on. And I think it's good terminology in some ways. I mean, there are people even now who still find judicial review somewhat misleading as a term to refer to what the court does here. But part of what Corwin is thinking about in suggesting, especially relative to judicial vetoes and nullification and the like, is to emphasize that the court is evaluating the constitutionality of a federal statute and can decide either way, and that both are part of that process of we're evaluating whether or not a statute is consistent with the terms of the Constitution, and we might decide it is, or we might decide it's not. And in each case, we're reviewing what it is you're doing, we're reviewing the work we're doing. And around the same time, the language of referring to judicial review in the context of administrative law is developing as well, where you're looking at an administrative agency and trying to decide, are you acting within the authority of the statute by which you were created, or are you not? And courts ought to be reviewing the actions of the administrative agency in order to decide you're acting within your authority, so you're fine, or you're acting outside your authority, and so you're not. And that was also called judicial review. So that's a little inconvenient that we use the same term to both talk about this administrative law context and talk about this constitutional law context. But it makes sense in the sense that they're doing very similar things. In both places, they're saying there's an organic statute that authorizes action, and we want to review whether or not you're operating within the confines of that organic statute that authorized you to take these actions in the first place. And we might decide you in fact are operating with them, or we might decide that you're not. And that's all part of that same process. We're not just coming in and vetoing things. We're not just coming in and nullifying things. Yeah. We are assessing what it is you're doing. And so it's also a very legalistic process. I mean, one thing that the veto language also implies is that it's a political process. And that's part of what some of the populists and progressives in that period that were sort of floating language were concerned about, is sort of emphasize this is a made-up power that the court's using as a hammer against legislatures. And part of what judicial review emphasizes, in the same way that's consistent with this administrative law context, is to say, no, this is a legalistic exercise the courts do. Mm-hmm. That we, sometimes our responsibility is to look at the law that authorizes some actor to take some action and see whether or not that law actually authorizes mm-hmm. them. And we might do that in the private law context, in the context of contracts, or something else, or a corporate actor and what they're doing. We might do it in an administrative law context about administrative agencies, or it might do it in a constitutional context, in the context of the legislature. But in all those cases, we're identifying a law that authorizes somebody to take action and determining whether or not it really does it. That's a very legalistic task, a familiar task that courts engage in other contexts. And so it is a term that at least invokes the legalistic nature of what the court's up to in the way that John Marshall would have appreciated, as opposed to implying that this is a kind of political power that the court is exercising against other political actors.
So this brings to mind for me, the French model of doing mm-hmm. this, which has been very influential. Right. Both the French and the Germans have extraordinarily influential models of doing what we could just broadly call constitutional enforcement. Yeah. So maybe right. we've got a big overarching right. category right. of constitutional enforcement. How do we make sure that our political institutions are complying with our Constitution? And in America, we call this judicial review. The French came up with a bit of a middle way. Mm-hmm. They didn't really want courts to do this, but they wanted some sort of a body, a judicial-ish mm-hmm. body that would do this, and they call it a constitutional council. So how does what the constitutional council does in the French system differ from what we expect American courts to do? I mean, you're drawing a bit of a distinction when you say American courts, judicial review in America is legalistic.
Right.
The Constitutional Council in France is doing something quite different.
Right.
Maybe could you help me understand the difference between that sort of European model of having a special body examine constitutionality versus having our courts do it?
Right. So some of the distinction is conceptual distinction. Some of it's a practical functioning distinction. And so the practical functioning distinction is, I think, more straightforward in some ways, right? And so part of what these European-style constitutional courts wind up being created do is that they are specialized bodies that don't have other legal and judicial functions, but whose only function is to evaluate the constitutionality of an act of usually legislatures, although sometimes some other bodies as well. So they're carved out from the general system. They don't operate under the normal rules of which litigation takes place. They're not hearing ordinary cases that come out through the system as a whole. They're dealing with questions that refer to them specifically about the constitutionality of some act that political actors are taking, that government officials are taking. And those might come before any actual action's taken place. So you might think that a law has been passed, and much like a presidential veto, where the president's looking at the language of the bill and deciding whether or not to approve it and allow it to be passed in a law, likewise, for a lot of these constitutional courts, they may only be looking at the language of the statute and deciding whether or not it can continue forward or not. So they're dealing with it potentially at a very early stage, as it's being adopted in the first place, and dealing with it as an abstraction as to whether or not it's consistent with the terms of the Constitution, which also allows you to then open up the door in all kinds of ways to who can bring those questions to the court. And so you can imagine having a very narrow funnel, so only a handful of people can bring these questions to the court, which is what the French largely have done, of saying only some leading political officials can bring these questions to the court. Or you can have it be very open-ended and say practically anyone can bring questions to the court, which some other systems have done. Makes it very easy for the court to get involved in hearing these kinds of cases as a whole. But it avoids all the kind of features of the American judicial review system of saying, okay, you have to have standing, you have to be involved in actual controversy, you have to have suffered an injury that really restricts the kinds of people who can bring the question forward, and also restricts fundamentally what kinds of questions can effectively get before the court as well. And so it makes it a much more political body in that sense, and a body that looks a lot more like a presidential veto as opposed to what a court looks like of it's part of a larger litigation process by which we're handling these cases, and the kinds of parties that can bring cases forward, the kinds of cases we're hearing are all handled as part of a larger litigation process with a larger set of legal issues associated with them, as well as this constitutional issue being one of those legal issues that we're handling.
So it's often said that the court doesn't that courts in the United States are passive.
Yeah.
They have to wait for someone to bring the controversy to them. It has to arise in an ordinary case. But Americans could be forgiven for hearing your description of what the French are doing.
Right.
This sort of constitutional council sitting up there waiting for some sort of percolating constitutional dispute to come to them so they can settle it and then sort of spit it back out and let the political system go back to operating according to whatever they've said about what the French Constitution means. And some people ask, how is that really that much different from what the Supreme Court does? I mean, it sort of sits up top, it waits for people to bring them issues. They'll pick 70 or 80 cases that they want to decide. Maybe half of those now are constitutional issues. So really only 40 or 50 constitutional cases a year. And then they sort of presume to sort of settle the issue and then give it back to the political process to go about their business. That leaves me with the question, is it still meaningful that we put constitutional review, the decision about whether a law is constitutional or not, in a judicial process and sort of make judges do it as part of a bigger litigation process, as you say? Is that still a meaningful distinction from what Europeans do, where they sort of set aside a special body, or at least the French set aside a special body that they take their constitutional disputes to, and then that sort of keeps the rest of their judicial system out of those big, divisive constitutional disputes?
I think it's still consequential, but it's probably less consequential than it once was. And because I think the American system has moved somewhat more toward a system that looks more like constitutional courts elsewhere. But it may be worth highlighting the conceptual issue I mentioned earlier about sort of what the European model was trying to distinguish itself from the American model to some degree. Because partially, some European scholars looked at what was happening in the United States relative to judicial review and thought it's a mistake to conceptualize your Constitution as being primarily a legal document that can be understood through ordinary legal means. These are fundamentally political questions. And so as a consequence, they should not just be entrusted to an ordinary judge. They need to be entrusted to a distinct kind of body that was specialized and expert in those kind of constitutional issues, which also frees your hand to then constitute a kind of constitutional court that is much more political, has different kinds of rules about how they're appointed, what kinds of tenure of office they have than ordinary judges, et cetera. In the European context, that often means you've got an ordinary court system that is not politically appointed, that comes up through civil service reform and tenure rules and the like. And so they're much more like a civil administration bureaucracy. And then you can separate those people out and say, okay, well, we've got our civil administration bureaucracy that deals with ordinary legal cases, but we're going to have this highly politicized body that's going to deal with our constitutional cases. And for us, we act like our Supreme Court justices or just like ordinary judges of all sorts, because any judge throughout the system can exercise this power of judicial review as part of their ordinary duties. So the Europeans thought that was a little nuts in a way of conceptualizing what they were doing. And so they wanted to restructure organizationally how you would proceed in order to emphasize how political that other task was. And we've obscured that by how we've done it. But I think we've also come to recognize more explicitly that's part of what we're doing. And among those things is by creating a cert process, for example, of saying in the early 20th century that the court can choose its own cases rather than just hearing mandatory appeals that come up through the system in the ordinary way. That has now merged into a system in which the court takes a relatively small number of cases. They have pure discretion over basically everything they hear. And they're primarily thinking about issues and questions, not cases per se. They're not resolving cases as a whole. They're resolving specific issues and questions that come out of those cases. And so it allows them to pick and choose to a much greater degree what issues they're going to hear, to focus much more on the constitutional issues. Is a reason why half of the court's caseload is made up of constitutional questions. That is not true at the circuit courts, right? So none of those boring bankruptcy cases and pension cases and all that stuff that ordinary judges have to deal with. Supreme Court justices don't want any of that. Yeah. So they're only taking the most interesting cases. And that includes a lot of constitutional cases in that sense. And so we've given them a tremendous amount of discretion about what kind of cases they want to hear. And that allows them to emphasize those abstract issues to a much greater degree. And the court itself has accepted a practice of facial judicial review that allows them to look at cases at a much earlier stage and evaluate statutes without a lot of application of statutes ahead of time. So it looked a lot more European in that process as well. Even so, except sometimes at the very extremes, I think, where it seems pretty distinct from that. But it's still often the case that this is bundled up with a larger set of legal issues. There's still limitations on who can bring the cases and what posture they can bring it up through the court system to get to the U.S. Supreme Court. That has consequences, I think, for both how quickly the court's likely to hear cases, what kinds of cases are likely to hear, what kind of remedies they can reasonably offer to the kinds of parties they're bringing cases in front of them. So I think it still has more legalistic paraphernalia surrounding how judicial review gets exercised in the United States. And that also comes with a set of constraints and limitations about what the practice looks like that would distinguish it from what would happen in sort of more pure European system. But I think there is more of a convergence of the two systems than might once have been the case. Certainly, I think the modern U.S. Supreme Court, I think, operates very differently than what the 19th century U.S. Supreme Court would have looked like when it looked much more like a traditional legalistic ordinary court kind of model.
And was deciding 1,200 cases a year.
It was deciding a tremendous number of cases, including a tremendous number of very boring cases. And at that point, hearing a tremendous number of stuff that was coming in through jurisdiction, through parties from two different states. And so, and as a consequence, we're often hearing state law cases that the only thing that made it federal was the fact that there were parties from two different states. So they were hearing divorce cases and contract cases and all the ordinary cases that ordinary judges would hear. So it looked like much more of an ordinary judicial body, and that included those federal constitutional cases that sometimes would arise as well.
I want to bring us back to a question about repugnant laws. The core of the book, the innovation here, was developing a data set, which is the Judicial Review of Congress data set, which you can find on your Princeton website. I assume we'll be finding that on a Yale website next year.
I am going to spin it off, so it's not completely tied to Princeton. But it will still be available at the Princeton website. Actually,
okay. And you've made that freely available. It's a tremendous resource. And looking at it, you have the thing that most people, I guess, would take interest in is the sort of the list of cases where Congress invalidated a federal statute.
Right.
And you find up through 2022. 353 instances of Congress doing that, or of the court doing that with a congressional statute. That's a lot more than the Constitution annotated, the Conan had found in the past. So that itself was significant. And then there's actually about 3 or 4 times that many cases, 12 or 1,300 cases total that you find that are actually occasions of judicial review of Congress.
Right.
So, you know, we have this data set of out of the, I don't know how many thousand cases. What's the total cumulative caseload of the Supreme Court over the years that was necessary to go to actually find these 1,300 cases?
So I knew this at one point, and I've now forgotten what the total number was. And I did not attempt to read literally every case the court decided. But
you had graduate students.
No, I did not. So this was all me basically.
Okay.
But the process. I did use the process of trying to do full text searches from things like LexisNexis, having where they have all the cases electronically searchable online, as well as the syllabus from the case and other materials from the case. So basically doing keyword searches to try to bring up as many potential cases that might fit the category as possible, and then read those.
Okay.
And so the result was I cast an extremely wide net that at least would capture all the cases that were in the traditional inventory. And things I suspected should be in the inventory at least. And the result of that was it brought up around 14,000 cases altogether. And so then I read all those. So that did exclude a lot of stuff, but
it's
of course,
immense.
It's
well,
immense.
Because the outsider might look at this and think, well, the court only decides 80 cases a year, right?
They didn't always.
They're all sort of on SCOTUS blog or something. Can't you just go search for these? And the fact of the matter is that for one thing, the United States reports where the court publishes are not complete for the early republic. I mean, anybody who's tried to get information about the Yale Todd case, which is really the first time the court invalidated a federal statute or upheld a circuit court decision doing that, knows the frustration of this, that no one thinks for the first decade or so this particularly important to publish these. In fact, if I remember right, Edmund Randolph, as first Attorney General, one of his proposals as Attorney General is actually to amend the Judiciary Act to require the court to publish its opinions and then for Congress to pay to bind those and send them out. And you would think Congress immediately went, yeah, it's important for people to have access to the Supreme Court's opinions. And in fact, I don't know when Congress actually starts making provision for this.
Not for quite some time.
It's well into the 19th century. Before that, I think it's just sort of Richard Peters and other federal judges or state judges actually taking initiative and doing it.
And you see a similar phenomenon in the state courts. There's just not a lot of recognition in the early republic that these things might be of general interest. And in part, there's a real sense that most of the kinds of legal questions the courts are handling are only of interest to a limited set of people, often only of interest to the particular litigants involved. And so there's no reason for anyone else to need to see the cases. And so not a lot of interest necessarily in recording and maintaining them.
So let's talk about the significance of your having found this list of cases. I brought up the sheer number. Which got 353 instances of the court having invalidated a federal statute. You've got 1,300 or so cases where the court's exercised judicial review in some form.
Well, and specifically to uphold a statute. So in addition to that,
So I guess this is one question is, why would we classify a case where the court upheld a statute, said, yeah, this is fine, as an exercise of judicial review?
Well, so as I said before, I think part of the logic of judicial review is precisely that question of evaluating what Congress has done and trying to make a determination, are they operating within the bounds of their legal authority, in this case, their constitutional authority. In that review process can come the answer of yes, you are, or no, you're not. And the ones that come to the conclusion that yes, you are just as much exercise of judicial review as the ones that say no, you're not. They appeal to the same authority on the part of the court, that the court has the authority to make that evaluation. And that's as true if the court decides that they came to the right answer as if they decide that Congress came to the wrong answer. They are trickier, though, to assess, right? Because like I said, there's a lot of gray area, I think, about what counts as judicial review in some ways. And that's even more true, I think, or maybe more true, when we think about questions about upholding laws. And so one way we might think about this is every time a court has applied a federal statute, they implicitly are upholding the constitutionality of the statute, right? Because the court presumably thinks it's engaging in an act that's consistent with the Constitution by applying the terms of a statute in the case in front of them. even if they don't say anything about the Constitution in that context. I don't think it makes sense to think about that as upholding the statute per se, because they aren't explicitly deliberating about the statute. They aren't making arguments about whether or not it's constitutionally acceptable. They didn't hear constitutional arguments about the statute. But there are cases where they do that, where they where they hear arguments about, is this constitutionally required? They themselves come to an explicit conclusion about whether or not this is constitutionally viable. They offer reasons why they think it is. And so I think there is a set of cases where it makes sense to say that the court has substantively considered, is this consistent with the Constitution or not, and actually come to a conclusion that yes, it is. And in that sense upheld that law against constitutional challenge.
One category of these cases is particularly important are instances where the court has altered its understanding of the statute to save it, right? The saving constructions.
Right.
How common is that? I mean, in the data set, that's a fairly common phenomenon.
I think it's not an uncommon phenomenon. And so, and there's a bit of a trick there as to saving constructions, I think, can potentially do a couple of different things, right? So one thing they can do is to say, we're going to interpret the language of the statute in a manner that's consistent with what we think the Constitution requires. And having done so, we can now say the statute's consistent with the Constitution and we're going to uphold it, right? But in doing that, they can also express a great deal of doubt that the actual language of the statute is inconsistent with the terms of the Constitution. And they can effectively lay down a clear constitutional rule about what is constitutionally valid going forward that is consequential. And moreover, they might be ruling out some applications that were previously being accepted. And so you have some cases, for example, where for example, somebody has been convicted under a criminal statute, and the court is now faced with, is that criminal statutory provision constitutionally valid or not? And they say, well, if you interpret it in the way in which this person was convicted, then no, that's not constitutionally valid. But we can reinterpret it in this other way where it would be constitutionally valid. And that's the correct way of interpreting it. And that's how it ought to be interpreted going forward. But by the way, that guy was unconstitutionally convicted. And so the consequence is you have struck down how it had been applied up to that moment, right? And now you've got a new statute moving forward in time that the court has now said is fine, but those past applications they've now ruled out as being inconsistent with the Constitution. So this can be handled in various ways about sort of that creative interpretation effort by the court. And what I don't want to do and don't try to do in the book or in the data set is parse whether the court got that right or wrong, right? I mean, so you might look at that and think the court's just playing games with how the statute is understood and interpreted. My key concern is what rules is the court laying down? What are the implications of having laid down those rules? Are they changing existing behavior or not? And did the court make the right call about how to interpret the statute? I think sometimes the way it's exercising judicial review does involve playing with the statute itself, trying to, which you say playing with it because it sounds like it's manipulating. In some cases they are. But at some level as well, if we're going to decide whether or not a statute is consistent with the Constitution, we have to know what the language of the statute actually means. And so there's necessarily a task of interpreting the statute. It's just there's on occasion going to be interpretations that we think are creative.
Well, now 230 years into the operation of the Supreme Court, we finally have something like a reliable database of the occasions when the courts claimed the power of judicial review or actually exercised that power by narrowing a statute or striking down the statute. Any thoughts on what you think constitutional scholarship should do with this resource now that you've generated it? And it being there is itself a tremendous help. I know I've consulted it from time to time just to say, well, what did the court say about this? Were there any occasions of the court asking this constitutional question before the Civil War? But what are ways in which you think we might productively use the data set?
No, I do. So I think so I'm primarily a qualitative scholar. So I am first instinct is to think in terms of qualitatively, what can you do with this kind of material? And I find it the same way of thinking. This helps think about the history of the court and how it's exercised laws. It gives you better guidance about thinking about what that history actually looks like in practice, and then trying to understand both the development of constitutional doctrine, but also thinking about the politics that the court's been involved in and what kinds of policies issues it's been involved with and like. And so I think this gives us much better landmarks than what we had before to sort of help guide us through thinking about the history of the court and how it's exercised judicial review over time and how it's inserted itself into the system. You can imagine more quantitative things to do with the data set as well, of trying to assess what kinds of laws are being struck down when, and what the kinds of political factors surrounding that are, or even legal factors. You can start trying to unpack about the statute, nature of the statute, or nature of legal issues the court's more or less likely to become involved with. I'm working a little bit now on a project, thinking some just about trying to identify what kind of rhetoric and argumentation the court uses in its constitutional cases, and having a more complete inventory of what are the constitutional cases, then I think allows us to think, okay, not just how do they talk about the Constitution when they're deciding Marbury, but also how do they talk about the Constitution and what kind of arguments they make when they're doing much more mundane cases is useful. So just trying to think about how common is originalist arguments, how common are textualist arguments, and the like, for example. I think unless you actually know what the landscape of cases are, you can't actually make good judgments about that. And so I think it provides that kind of material. I think there's a really interesting project to be done about what the consequences of the court ruling in these cases are. How often does Congress go back and revisit that statute and try to modify it in light of what the court did? How does it change actual governmental practice of how the statute gets implemented over time as a consequence of what the court did? I think we have all kinds of open questions about that kind of thing, and I think this provides a better resource for trying to begin the process of doing the kind of research that would be necessary to really assess how much is the court actually getting in the way of Congress as it exercises power over time, and how much is Congress figuring out creative ways of working around what the court's doing.
It's an exciting direction. Well, we'll be looking forward to seeing what happens as you move to Yale.
Thank you.
Exciting new developments there, and I appreciate you taking a few minutes to chat with us.
Absolutely. Thank you very much.
All right.
Sure. Went much longer than you intended.
It did. I don't actually know where we are, but I know I had at least 2 questions I needed to ask.
That's the way these things work.
That's right.
This is more like 40 minutes rather than 25 minutes.
I think so. Yeah, I think we're well past. That's right. Okay. Assume